Okay, good evening, everyone. My name is Joel Watts. I'm the Deputy Clerk and the Drainage Board Recording Secretary, and I'll also be Recording Secretary for this quarter revision for Thursday, January 15th, 2026 for the Waite Municipal Drain. The quarter revision members were selected by the Drainage Board earlier this term of council, and the members are to be Councillor Ashmore, Councillor Joyce, and Charlie Clark, with our alternates Robert McEachern and David Skrabek. With us today, we have Councillor Joyce, Robert McEachern, and David Skrabek in the room, and Councillor Ashmore. It is my understanding that Councillor Ashmore, while he is a regular member of the quarter revision, you have a declaration of pecuniary interest at this time?
Yes, I do, Joel.
All right, and the nature of your declaration is?
Just relationship with the just a recent relationship with the with one of the family members.
Okay, so due to the pecuniary interest, it would be advisable that Councillor Ashmore not take a seat as the quarter revision tonight, and then one or both of the alternate members would take a seat, as Charlie Clark is also not here. So then I will declare that the members of the Waite Municipal Drain Court of Revision for January 15, 2026 will be Councillor Joyce, Robert McEachern, and David Skrabek. Thank you, Councillor Ashmore.
Yeah.
You're welcome to continue to watch the proceedings, however.
Okay, thanks.
I will note Councillor Ashmore is also muted at this time as well. So the first order of business is to appoint a chair for the quarter revision. And so I'm going to call upon the members of the quarter revision for a nomination for the position of chair. Member Skrabek?
I'll nominate Councillor Dan Joyce.
And Councillor Joyce, do you consent to the nomination?
Yes, I do.
Perfect. All those in favor? Thank you. Councillor Joyce, you are now going to proceed as the chair for the quarter revision. So I'll get you to come to the dais, and then bring your name tag too. That'd be great. Thank you. And then we'll follow through with the remainder of the agenda. Thank you.
Okay. Well, I guess I have to call for any further declarations of pecuniary interest on today's agenda. Oh, sorry. Oh, yes, I skipped something. Sorry. Adoption of the agenda. I need a mover and a seconder to adopt today's agenda for a quarter revision. Moved by Robert McEachern and seconded by David Skrabek. All in favor? Thank you. Now, declarations of pecuniary interest from our members in the quarter revision. We're all good there? Thank you. The quarter revision will now consider the preliminary adopted municipal drainage assessment schedule for the Waite Municipal Drain and any associated appeals. All comments received today by the quarter revision may be considered as evidence in accordance with the Drainage Act. It is my understanding that one appeal was received on January 5th, 2026. And Deputy Clerk, is the appellant D. Gardner attending the meeting today?
They are present.
Okay. And with the appellant D. Gardner, would you like to read your appeal for the record? Pardon me?
Mr. Gardner has requested that I read his appeal into the record. This was supplied to all the members of the Court of Revision. His appeal was received at the office of the City Clerk on January 5th, 2026, in accordance with the notice that was circulated. The appeal from Mr. Gardner says, to whom it may concern, I'm writing in connection with the recent cost-sharing notice issued to me regarding the proposed installation or improvement of a drain pipe on my property. I respectfully request that my property be removed from any cost-sharing requirement for this project for the following reasons. First, I disagree with the allocation and the amount of the cost being attributed to my property. The proposed works were not initiated at my request, nor do they address any issue or deficiency originating from my lands. Second, my property derives no direct or indirect benefit from the proposed drain. The request for the drain was initiated by a neighboring property owner who will be the primary and substantive beneficiary of the works. The drain does not improve drainage, access, usability, or value of my property, and therefore the assessment of costs against my lands is neither equitable nor appropriate. Third, I note that this matter was not disclosed to me at the time I purchased my property 5 years ago. This transaction was facilitated by the neighboring property owner's spouse who acted as a real estate agent for the sale. At no time was I advised of any existing or anticipated drainage issues, pending applications, or potential cost-sharing obligations relating to the municipal drain works affecting the property. Had this information been disclosed, it would have been a material consideration in my decision to purchase. Given the above, I respectfully request that the municipality reconsider the assessment and remove my property from the cost-sharing requirement associated with this project. I would appreciate written confirmation of this review and any further steps required on my part. Thank you for attention to this matter. I look forward to your response. David Gardner of 804 Chambers Road.
Thank you, Deputy Clerk. Anything further there? Thank you. All right, we're moving into step 3.1. Would the engineer assigned to this municipal drain, Mr. DeLay or Mr. Vanderveen, care to provide evidence regarding the appeal that was just read into the record?
Perfect. Thank you, Mr. Chair. And Joel, I can share my screen from here. Just let me know if
you should be able to.
Okay. Are you able to see that okay?
Yep, it's in the council chambers.
Perfect. So I just have a couple slides here. We can go through and have some background information and happy to answer questions after this. So let's start here, a bit of a summary. So I've reviewed Mr. Gardner's appeal. As Joel said, the appeal was filed on January 5th in advance of the 10-day deadline. We have the Gardner property assessed for approximately, 5.23 hectares within the watershed. That area we factored with an outlet factor of 1.0, similar to, which would be equivalent to mowed grass or what we'd use for an agricultural property. And so then they have a net factor of 1.0. And in this case, when I looked back at the assessments for the surrounding properties as well, given the size of the property, we haven't taken the impervious structures into account. So because those go onto a larger area where water can infiltrate, we've considered the whole area as mowed grass, which is kind of a break that we've given all the properties in this case because of the larger size of the property versus the dwellings or garages. So here's a picture or an aerial of the property. In this case, the watershed line, which I'll show you on the next slide, kind of goes through the high ground, which would be in the home and the garage here. And so this portion to the north does not enter a watershed. This area to the south comes to the south end of the property. And towards Highway 35 here, this is where we actually have the drain crossing. So now here we are at the south end of the property. The amount of work on the Gardner property that's proposed currently, there's a catch basin at the eastern edge of the property where we meet the Highway 35 property line. That basin, catch basin, would be on the property line. We have about approximately 50 meters of 21-inch diameter HDPE pipe, plastic pipe. So the drain would be underground in this case. We have another concrete catch basin at the upstream side on the Waite property line as well, another basin at the property line. And the reason why we went with a pipe in this case is because at the time we were looking at design options. The Clive property at the time wanted a pipe downstream. We were going to do a pipe under a highway. And as I recall, the Waite property was really indifferent what we did in this location. So we proposed a pipe, and that was not that was accepted through the meetings at the time. Mr. Gardner, I don't believe we have met before, and the previous owners, I don't believe they attended the public meetings we had as well. So the design option as presented is what we move forward with. So if we look at the assessment breakdown here, I don't want to get too into the weeds here, but essentially when we looked at this property as part of the larger scheme of this eastern branch, we broke the sections of the drain down into sections that we use for our assessment basis. So essentially the very bottom end would be on the Stewart property. That would be section E1. Well, this property has, I think, 5.2 hectares. So that water would be contributing and using those downstream sections. So that's what I'm indicating by outlet here. So they were assessed about $1,460 to use section 1. Section E2, as we move through the rail trail and along the rail trail, channel improvements in there, they were assessed $860 towards that section. Section E3 is a more expensive section through the former Clive property. In there, we've got a section of overland swale. We've got a section of pipe that goes through that property, and all the upstream section or upstream areas pay to use those sections. So they were assessed $5,260 to that section. Section E4 is across Highway 35. That is, the majority of that cost is covered by or assessed to the MTO under Section 26 of the Act. Because of the presence of the highway, they pay those increased costs. So they're paying $260 towards that section. And then Section E5 is on the Gardner property. Now in this location, you can see I've got benefit beside it. So we're talking about Section 22 of the Drainage Act, and really the presence of this municipal drain and legal outlet on this property is why we're using benefit assessment on this property. So it's typical in our logic to assess, we break the catch basins on property lines into half. And this property could be drained and tile drained in the future and tied into one of the downstream basin. So we've assessed half the cost of that downstream basin to the property. So that's the downstream, about $2,700 for half that catch basin. The other half is assessed to the MTO property. In the upstream basin, we've assessed half of that cost to the Gardner property to protect that property from flooding. The water will get into that basin, get into the underground system. So that's $2,700. The other half of that catch basin is assessed to the Waite property. There's also an administration charge of the engineering that goes into that design assessed to those catch basins as well. So we have what we call a total specific assessment, the $2,700 times 2 plus the $2,160 plus the section benefit. So since that that pipe is on their property, that's the assessment share of that property's benefit. Similarly, there's a benefit charge for having that legal outlet upstream to the Waite property. The sections downstream that are on those respective properties also have those benefit charges. So in total, if we add up all of the sectional charges here, E1 to E5, we end up with a total assessment of $18,980. And on the last slide here, if we look at this, we have that total assessment, $18,980. And if we look at the assessment sheet in the overall net assessment sheet in the report, we'll have a total assessment, and then we'll be taking off for those properties who would be eligible for the OMAFR grant with farm tax class. They would have a 1/3 grant. The Gardner property does not currently have that status, so there is no grant there. They do have allowances because the drain is crossing their property. So off of the $18,980, we'd take off $1,340 because the drain is going on their property. They have to be compensated using allowances. So the net assessment, or the take-home assessment for the property, would be $17,640. When I looked at the other properties along the drain earlier today, we did apply the same logic to the Gardner property as we did downstream on the Clive and so on, and upstream on the Waite property. So very similar process that way. Be happy to answer any questions if we have any.
First, to our members on the Quarter Revision, do you have any questions for the engineers? Okay, thank you. I do. Thank you for that, and just want to clarify that the Gardner property, I can't see, the 5-point-something hectares, 5.22, I think it is. That is not the entire property. That's just the watershed area that we're talking about.
That's correct, Mr. Chair. I'm actually going to, if I can come out of this screen, go into the PDF here. So this is the drawing from the report. And that's the overall view of the eastern branch. However, if I go up one here, and we'll see the actual watershed shown in the pink or magenta line here. This is the Gardner property shown here. So in the previous drawing, I had shown I guess I can't do that. I'd shown the outline of the entire property. And as I had mentioned before, this northern part of the property, as you can see with the flow arrow, is actually heading towards this intersection. The 5.23 hectares, that's the area within the watershed that's coming down towards our drain at the southern part here.
Thank you. My second question is mown grass, but the soil is still, is it considered A1 arable land for farming?
That's a good question. I'd have to refer back to the report for that answer. I don't have that off the top of my head.
Okay, and to clarify, the benefit increases the value of that land, correct?
The benefit increase, as we had discussion on this yesterday, the benefit is derived from the amount of work done on the property. And another way, if we look at the definition of benefit under the Drainage Act, we're talking about an improved appearance of land, improved workability of the land, the ability to drain the land. The presence of this legal outlet would really be the big one here. Sid Vanderveen had the point yesterday that if we had the property appraised with and without a legal outlet, we would see an increase in land value with that, the presence of that legal outlet.
Okay, thank you. No further questions. Does the appellant, Mr. Gardner, do you have any comments or questions? Yeah, you got to speak in the microphone so everybody can hear.
Can you hear me now? Yeah, I don't really have any questions as far as how it works. I mean, I saw the report, I understand the report. I don't have any drainage issues whatsoever. The land's flat, I don't have any flooding. There's really no need for this, to do this for my property. There's absolutely no need whatsoever. There's no drainage problems whatsoever. Even in the spring, I mean, everything melts off, it just runs off. So I don't understand why I have to pay 18 or whatever it is, $1,000 for something that I don't need. There's scenarios that it could add value one day if I ran, some drain pipes to it. It's not something I'm gonna do, right? I'm not draining anything. There's nothing to drain. So that's my big thing with this is, and it's not even reasonable priced for what it is I'm getting out of this. I don't even want it. I can't stop it. That's fine. You need to run it through there. Okay, no problem. But we're not draining anything off of my property. I don't have a flooding problem. I don't have any water settling, right? I have none whatsoever. And even the property that needs the drain, that property is not even draining onto mine. I don't know where the water is going, but it's not rolling through my property. So I don't understand. If they need a drain, I get it. But I don't understand why I have to pay that cost for them to have a drain when I don't have a drain problem. I don't have a flooding problem. So that's my big thing. It's not the science behind how the whole thing works. I understand it. It's just that I shouldn't be included in this because there's really no benefit to me. I don't have any issues requiring a drain. If the neighbor has that issue and they need to run the pipe through my property, no problem. I don't have a problem with that. I'm not fighting that. I'm not opposing that. But to then have me pay almost $18,000 for something that does absolutely nothing for me, that's just benefiting a neighbor, that's not fair. And that's basically that's my problem with this.
Thank you for your comments. The reason for this is the way the Drainage Act works. And it's a provincial Drainage Act and we're just following. In the Court of Revision, you have to prove you're not getting a benefit. You can't just say, I don't like it. So we need something from you to demonstrate you're not actually receiving a benefit by these drainage works.
But I mean, I'm sure you've done extensive research, pictures, all kinds of graphs, charts, sonar, I don't know what you've done. But I mean, you would have the information that shows there's no water on my property. You're putting a drain to get rid of water, but there's no water there. At no point do I have any water. You understand? I mean, in the spring, when the snow melts, sure, you'll see water running off for, the first week. And that's it. I don't see any water. I mean, I cut the whole thing. I would be stuck every 2 seconds. There's no water on the property. So, I mean, the engineers would have this information showing that there's no water. I mean, I shouldn't have to go and now prove and take pictures how do I prove this? The engineers have already done this work and they very well know there's no water on this property. There's no water settling. There's no water coming up anywhere. I don't have any water. So I'm paying for a drain for something I do not need. I'm not solving any issues. That's all I'm saying. I mean, so now I'm being asked to prove that it's not a benefit. I don't have any water. There's no water on the property.
Okay, where it comes from is the value of your land is increased now by that's the wrong word, by drainage. So basically, were you to sell it to somebody or farm it yourself, there's the value, and that's where the benefit comes from.
If this was septic, or if you're running water, I probably wouldn't argue. But this is not septic. This is just draining with drain basins on the ground. That, like I said, we're fixing a problem for me that doesn't exist. Isn't the property going to be branded once it has this?
Sorry, say that again?
Is the property going to be branded? Or is it going to be, because now I can't build over that. I can't do anything over that, right? So that's a negative on the property, no?
I'm not familiar with building, I'm not into zoning and that. You probably couldn't build on the drain itself, the tile, but other parts of your land you can probably build according to zoning acts.
What would be of value if there was septic, if there was sewage? If there was sewage on there, it would add a huge amount of value. And if there was sewage, I wouldn't argue. But this is just a water drain, draining no water that I have. So that's my problem with this. This is my concern, is that I'm paying for something that is doing nothing for me whatsoever, because it's fixing a problem that does not exist on my property. If it exists on the neighboring property, I understand. They need to run the pipe through my property, I also understand. But to have me pay to fix a neighbor's problem is not fair. That's my issue. That's why I'm here.
Are you familiar with the Drainage Act itself?
I'm not familiar with all the drainage acts. I didn't go that far. I'm just a simple guy that just came down to talk about what I saw on the package that was sent to me and the assessment that was given to me. And I just know that I don't need it.
I understand, but you need to understand we are following the Drainage Act, and the way it's set down by the quarter revision today is following procedure. That's what we have to do. And we're at the stage here where you have to demonstrate you're not getting the benefit.
Mr. Chair, if I may.
Go ahead.
Yes, Mr. Gardner, I'm empathic to what you're saying here, and I think we could give some background maybe to discuss some of those issues you came up with. I can see, Sid, if I can call on you maybe to answer a couple of those questions. I could see you wanting to answer a couple of them as we were discussing them maybe.
Sure. There's a few things that I would like to contribute. So first of all, in Ontario, every property drains. It may drain in different ways, but it does drain. And contrary to most popular understanding, most properties don't have the right of drainage, the legal right of drainage. And so one of the things that you are gaining with this is actually the legal right to drain. And to go downstream through the MTO property and further downstream as well. The other thing that is whether you see it or not, whether you intend to use it or not, but the fact that there's an ability to outlet is into this pipe with a potential tile drainage system is a value to the property. It would be viewed by any potential purchaser who intends to farm that land as an asset. It's something that's important to them. So those are a couple of points. The other thing that I wanted to, if I may, it can, one low-hanging fruit that's available is the farm property class tax rate, and it would be, I would encourage you to investigate that. Having your land designated at the farm property class tax rate reduces your annual taxes on the property itself by 75%. So there's a huge property tax value if you can get the farm property class tax rate. In addition, if you have the farm designation, it also provides, the province provides a 1/3 grant towards your assessment on your property for this drainage system. So the figures that Mr. DeLay showed earlier would automatically be reduced by 1/3, and then you take your allowances off of that. So it might end up being down to, I don't know, $12,000, $11,000. So a significant savings as well. And and I can direct you to some information on how to apply for the farm property class tax rate. My guess is your property is already designated as agricultural, you may just have to get the land use, the farm property class tax rate. Anything to add, Mr. DeLay?
No, I think that was great, Sid. And Mr. Gardner, if there were any other kind of specific questions in there, like I said, we can empathize with you because it's a shock to the system. You're not going through this every day. But the big one I see with your property is that, to Sid's point, we have to assess it based on what you could do with your property, not necessarily how you are currently using it right now. And when we go through and look at, the drain has to cross your property, and so you could tile drain that property in the future, and things can change over time. And so if you, for example, sold your property and someone else tile drained it, well, right away they've got a legal outlet. So we have an obligation as duty as the engineers under the Drainage Act to be fair and impartial when we look at the assessments for your property versus others, and how large your property is and how much of your property is within the watershed. It may not appear fair to you and to other landowners, but we have to do that on, when we're looking at the project itself. And so, therefore, that's why we have the appeal body like this, where you're able to appeal and say that I don't think this is fair. And we're having the court revisions exactly for that, for the court to hear that appeal. But if you had any other questions or anything else we could address at this time with information, be happy to.
If I may also, if anyone is interested, I've got on my screen right now the information about the farm property class tax rate program. I can share the link with you. I can actually share screen and show you a little bit about how it works as well, if the court and Mr. Gardner are interested.
I'm going to interject here. We can come back to that later. Thank you.
Thank you.
Yeah. Any further comments or questions, Mr. Gardner?
No, I've already said what I needed to say.
Do members of the Court of Revision have any other questions at this juncture? Okay. Clerk, are there any other appeals? Late appeals?
No further appeals have been received in the clerk's office.
Has the engineering department received any late appeals?
Through you, Mr. Chair, the engineering department hasn't received any late appeals.
Does the engineer assigned to this municipal drain wish to make any final comment on the engineer's report and the preliminary bylaw?
Thank you, Mr. Chair. Not at this time.
And the appellant, Mr. Gardner, do you still wish to proceed with this appeal? And members of Court of Revision, do you have any final questions to the engineer or the appellant? Okay. Oh. I do have another question. Mr. Gardner, have you discussed with your neighbor, Mr. Waite, about taking on some or all of the fees that are being assessed against you?
No, I don't know him. I've never met him. I don't even know where to find him. Is he here?
Last in the gallery is Mr. Waite in attendance.
Okay. Who's Mr. Waite? Okay. No, I've never met Mr. Waite, so.
Well, now you're introduced.
There it is.
So, a couple things here. With no further comments or appeals to be heard on this municipal drain, the Court of Revision will now make a decision on assessments of provisional bylaw. We're going to recess and talk about this, Mr. Gardner. But before I do, just one more thing is the way this works. The engineers have priced out the project. So if we're to discount one property, just say for argument's sake, $5,000. That $5,000 has to be assessed to another property. It has to be paid for some way. And that's why I asked that question. So it just can't disappear. It has to move from one to another. So that's again how the Drainage Act works. Okay, on that note, we're going to recess and we'll come back. Thank you.
And Okay, to the members that were on Zoom, we're about to reconvene.
Very good, thank you. Okay, to the appellant, Mr. Gardner, we have deliberated, and the Court of Revision has heard evidence presented today by yourself, the appellant, the engineer, and respectfully, we're denying the request. A formal notice with reasoning will be delivered to you in writing. I will verbally, in essence, say, because the property still has potential to be used for agriculture and has been assessed at similar rates as nearby agricultural properties. The intention of the Court of Revision is to keep the schedule of assessments as printed in the provisional bylaw. Before we finish this proceedings, though, I'd ask you to remain behind because myself and staff are going to help you in some other ways. You have, if you're dissatisfied with this decision today by the Court of Revision, you may appeal this decision to the Agriculture, Food, and Rural Affairs Drainage Tribunal by filing a notice of appeal with the Office of the City Clerk within 21 days of the date of this decision. And can I get a mover for this motion? And thank you. Moved by David Skrabic that the assessments contained in the Waite Municipal Drain Report by Drainage Engineer E. DeLay and has provisionally adopted by bylaw 2025-140 are hereby confirmed, and that there should be no other appeals heard within the prescribed timelines, that council proceed with a third reading of bylaw 2025-140 at the next possible city council meeting. And I need a seconder for this. Mr. McEachran, are you seconding this? Can I get a second? Thank you, Robert McEachran is seconding the motion. And all in favor? Thank you. And can I get a motion to adjourn this Court of Revision? Motion by Robert McEachran. Thank you.